chair recognizes the senator from Washington, Senator Burns.
Thank you, Mr. President. Mr. President, ladies and gentlemen of the Senate, I stand before you today to give you some compelling reasons as to why you should support LD 1428, an act to protect the religious freedom. Unfortunately, the downside of going second is that you're going to have to listen to some things over again, hopefully with a different slant, certainly with a different interpretation. Before I explain 1428 and the reasons why you should support it, let me describe the recent actions of this bill. The public hearing for LD 1428 was held about a month ago and drew so many attendants that two of the overflow rooms were unable to contain everyone. Many of the people, which included members of the Islamic, Jewish, Protestant, Catholic, and Native American faiths, as well as more than a dozen legislators, spoke in favor of LD 1428. The number of supporters outweighed the bill's opponents by 7 to 8 to 1. Many of those supporters were average Maine citizens who not only expressed support for the bill, but also offered testimonies as to how their religious liberties had been threatened here in Maine. Compare this to those representing the special interest groups that spoke against it. With such widespread support and undeniable examples of risk of religious freedom, I was disappointed when the Judiciary Committee voted not to pass and to defeat LD 1428. Unfortunately, this vote rested on misconceptions about the scope of this bill and the rejection of the historical records regarding similar legislation in 18 other states that have just been mentioned here, and the federal level. I would like to address these misconceptions and explain how LD 1428 is reasonable and much needed, a measure to adequately protect the rights that have been guaranteed to all citizens. First, though, I would like to explain that LD 1428 aims to do. It would require that any governmental action infringing upon a person's free exercise of religion must further a compelling governmental interest and be accomplished in the least restrictive way possible. I think those are the most important issues to remember here, and I'm going to repeat them again. Must be done have a compelling governmental interest and be accomplished in the least restrictive way possible. Or, as President Bill Clinton said in 1993, when he signed the legislation on which LD 1428 is based, and I quote, "This law basically says that the government should be held to a very high level of proof before it interferes with someone's free exercise of religion." I didn't say that. President Clinton said that in 1993. LD 1428 is just that. It requires the government to seriously weigh the religious liberty interest of its citizens against its own interest. And this is about government. This isn't about private citizen versus private citizen. This is about our government, ladies and gentlemen. It does not create any new rights. It does not, as the bill opponents would suggest, allow religious people to get away with anything that they want to. It does not guarantee religious claimants victory in conflicts against government action. And it does not implement an unknown, previously untested standard for government action in the area of religious liberty. Instead, LD 1428 simply requires that the government have a strong justification for infringing on the free exercise of religion, which is exactly the kind of restriction government should have when they are dealing with fundamental rights, which this is. There are some who argue, however, that Maine citizens don't need LD 1428 to protect their religious freedom, as the First Amendment already protects religious freedom. The simple answer to that is not like it used to, ladies and gentlemen. This is because in 1990, as you heard before, the U.S. Supreme Court unraveled decades of religious exercise case law and handed down in its decision in Employment Division versus Smith. In this decision, the court narrowly decided that government action infringing upon religious exercise did not have to have strong justification, as it has been for requirement for decades prior to the Smith case. Instead, the Smith court said government action could infringe upon religious liberty as long as the action was religiously neutral and generally applicable, a standard, by the way, which the Maine's Attorney General says applies to the free exercise of religion here in Maine. I hope you keep that in mind. For some of you here today, this may not seem like a problem. You may feel that the government should not have to have a strong justification before interfering with religious liberty, or the religious liberty should be subjugated to generally applicable laws. Let me remind you, however, that the general laws can affect people incidentally, impeding on a free exercise of religion without the government intent to do so. Worse, generally applicable laws can and have been used to persecute religious minorities, even in the United States. For example, in the 1920s, the Ku Klux Klan helped pass a public school law in Oregon that would have shut down every Catholic school in the state. From the 1930s to the 1950s, towns across America imposed ordinances to stop the Jehovah's Witnesses from proselytizing. Ordinances that triggered the chain of events resulting in extreme violence against the Jehovah's Witnesses for refusing to salute the flag. And throughout the 19th century, Americans in New York, Ohio, Missouri, and Illinois not only persecuted Mormons, but forced them to move from state to state. Remarkably, it was religiously neutral, generally applicable laws that did not even mention religion, that were the center of these incidents of intolerance. These, my fellow senators, are the kinds of laws that would be upheld by the Smith standard. The standard that, and let me remind you, is what the Maine Attorney General says that we have here in the state of Maine. Thankfully, the fact that the generally applicable laws can result in religious persecutions and intolerance was not lost on the majority of Americans in the wake of the Smith case. Americans understood that the Smith decision practically eviscerated religious liberty. For example, in written testimony before the Senate Judiciary Committee in 1992, then President of the ACLU, Nadine Strawson, strongly criticized the Smith decision. She stated that in Smith, the court essentially, and I quote her, wrote the First Amendment's guarantee of the free exercise of religion out of the Constitution. And again, I'll remind you, that wasn't me that said that. That was the president of the ACLU that said that, ladies and gentlemen. Consequently, more than 50 other groups along all points of the political spectrum, including People for the American Way, Southern Baptist Convention, the American Muslim Council, and the ACLU, pushed Congress to respond. In 1993, these groups were successful when Congress passed and President Bill Clinton signed the Religious Freedom Restoration Act, or referred to as RFRA. This law, which is practically identical to LD 1428, restored the pre-Smith requirement that government must have a compelling interest served through the least restrictive means in order to infringe upon religious liberty. In 1997, as you heard before, however, the Supreme Court decided in the city of Borne versus Flores that Congress did not have the authority to levy the Religious Freedom Restoration Act against the states. As a result, adequate protection for the free exercise of religion has to be settled in each state. LD 1428 is Maine's opportunity to provide that protection. The same protection that 18 other states, including Connecticut, Pennsylvania, and Rhode Island, our neighbors, have provided to their citizens, and the same protection that a large bipartisan group, including the ACLU, helped to secure on the federal level through the Religious Freedom Restoration Act. Why then wouldn't Maine want to do the same? Why would Maine's lawmakers, who are responsible to provide full protection for the rights and guarantees to our citizens, fail to safeguard these fundamental rights? Unfortunately, a majority of my colleagues on the Judiciary Committee have found reasons to do just that. Reasons that I mentioned, misunderstand the necessity and the scope of this bill. First, opponents argue that LD 1428 is unnecessary. They say that Maine already has enough protection for religious liberty, and Maine citizens are simply unaware of what their rights are. Apparently, then, Maine's top lawyers, public policy experts, and the Attorney General herself are also unaware of what these rights are, as none of these experts could agree during the public hearing or subsequent work session on which standard applies to the free exercise of religion here in Maine. In other words, none of them could agree on whether or not we are under Smith or not. In fact, the Attorney General and later Representative Moriarty on our committee used the exact same case, Anderson v. Town of Durham, to reach two opposite conclusions, with the Attorney General saying that we are under the Smith case law and Representative Moriarty saying that we are not. If there is so much confusion, then why in the world would the legislature not act to clarify the standard review for the free exercise of religion? Why would you put the fundamental rights at risk? Why would you not ensure that all Maine citizens have sufficient protection for the rights guaranteed to them by our Constitution?